me to hold an inquiry to consider an application by Renewable Energy Systems Limited to construct and operate the proposed Kintradwell wind farm. The application process proposes the construction of up to 15 turbines, not exceeding a height of 149.9 metres, a battery storage facility and associated infrastructure. And the wind farm would be located on the Kintradwell estate, located to the north of Brora in the Highland Council area. The applicant is seeking consent also under Section 36 of the Electricity Act 1989, and as part of that process, it's also seeking a direction under Section 57(2) of the Town and Country Planning Scotland Act 1997. It's amended that deemed planning permission is also granted for the proposed development. Now, at the conclusion of the inquiry session last November, we agreed that we would reconvene to discuss the National Planning and Energy Policy Framework relevant to the consideration of the application once NPF4 had been published and laid before Parliament. Now, as we know, NPF4 was approved by Parliament on the 11th of January, and the letter subsequently issued by the Chief Planner indicating that NPF4 would be adopted on the 13th of February 2023 at 9 AM, meaning that it will be in force, and NPF3 and Scottish planning policy will be superseded from that date and time. Also, the Scottish Government has recently published a revised onshore wind policy statement, a draft energy strategy and just transition plan, hydrogen action plan, and a draft biodiversity strategy. Given that my report to Scottish ministers will be submitted sometime after the 13th of February, and assuming matters progress as planned, NPF4 and the onshore wind policy statement will provide the overarching policy context within which I'll be writing my report. Before we start our discussion today on these documents, I have a few things to say about today's hearing. Firstly, I don't intend to revisit in detail the policy topics that we've discussed previously, although I appreciate that it might be necessary to touch upon some of them as we discuss matters today. Now, with that in mind, you should have received an agenda for today's hearing, which I circulated in draft comment before confirming the topics for discussion, and thank you for your input into that. I will lead the discussion based on the topics listed on the agenda. Now, I've read the original, updated and supplementary hearing statement, so there's no need for parties to repeat their cases in full. But as we go through the points on the agenda, there should be opportunity for all to get your points across. As before, there will be no direct cross-examination of those taking part, but you can ask questions of each other through me if you don't understand or you want to clarify something that's been said. Secondly, I wanted to thank the parties for preparing updated and supplementary statements on time, particularly given the dates for submission fell just before and after the Christmas New Year break. So thank you very much for your efforts in that regard. Just a few housekeeping matters. As you'll be aware, today's hearing is being broadcast live on the DPEA website, and a video recording of the hearing session will be retained on the website until ministers have taken a decision on the application. By taking part in this session, you are consented to being filmed and to the use and storage of those images and sound recordings and any information relating to them for webcasting and training purposes, and for the purposes of keeping historical records and making those records available to the public. It is my intention to take regular breaks throughout the hearing, perhaps every hour or so, given how tiring it can be looking at a screen for too long a time. We'll break for lunch at a convenient point if we've not covered everything on the agenda by 12:30 or thereabouts, and we can agree how long we take later on. And if you do feel the need for a break before I suggest one, please don't hesitate to ask. To address any difficulty with the broadband connectivity, could I ask those who are only observing today's proceedings to mute their sound and switch off their cameras. And of course, those participating should keep everything switched on. If anyone does encounter any difficulties seeing or hearing proceedings, please let me or Ewan know. You will be overseeing proceedings throughout the morning. And finally, could I ask all participants to ensure that their mobile phones are switched off or at least switched to silent? Thank you. Now, are there any questions about my introductory comments before we move on? Mr. Trenick.
Well, thank you, sir. Very clear.
Okay, Ms. Finlay?
No, thank you, sir.
Okay. I'd just like to start by taking a note of the names of those who will be taking part in the hearing session this morning. If I could start with you, Mr. Trenick.
Thank you, sir. Yes, and good morning. I am Marcus Trenick, a solicitor of King's Counsel. I'm appearing with Jonathan Easton of Counsel, who sits in the other photograph you'll see on the screen, two to my left. I'm instructed by Lizzie Tainch of Wright Johnson Mackenzie, who's putting up her hand. To my left is Simon Heinsohn, who will be the principal witness in this session, who you saw before at the inquiry.
I think possibly Simon Herriot.
Simon Herriot, indeed. We'd love to have Simon Heinsohn, but he's on the other
I
side.
was just checking Simon Heinsohn hadn't changed sides. Although I'd be looking forward to call Mr. Herriot on my side.
You may, of course. Mr. Herriot will be the principal witness, assisted by me and by Jonathan Easton if required. Also in the room, as well as Lizzie Tainch, we have Paula Batchelor and Gavin Shirley of RES, and to Lizzie Tainch's left, Lauren Farlan of Wright Johnson and Mackenzie. And I'm grateful to Mr. Finlay, and thank you very much.
Okay, thank you. Mr. Finlay.
Good morning, sir. My name is James Finlay, King's Counsel, Scotland and England and Wales. I'm appearing this morning solely for Highland Council, although Loth residents are undertaking a watching brief. I have one witness, Simon by name, Heinsohn by surname, and we will endeavour to share the answers as we go on.
Okay. And was it Miss Royce and Mr. Whitfield that I saw from Loth residents?
It wasn't. It was indeed.
Super. Thank you.
So they appeared briefly and waved at you.
Right. Thank you. Well, good morning, both. Okay. Turning to the second item on the agenda. Before we discuss NPF4 in detail, I have a few general matters that I'd like to discuss. Now, first, I'd like to hear from the parties on the weight to be given to the approved NPF4 as it moves through its final procedural stages towards adoption. Mr. Heinsohn, if I could start with you. Mr. Herriot addresses this matter for the applicant in the introduction to his updated December statement, but it's not something that you explicitly commented upon in your statements. And I just want to be clear, what's the council's position on this matter? What weight should the decision makers give to NPF4 and its policies in this case at the present time and when adopted?
Good morning. It's the council's view that at the present time, unless something happens in the next two and a bit weeks, that it should be given significant weight as an approved document. It would obviously again it would have significant weight, slightly more than what it has now at the time of adoption as part of the development plan on the 13th of February. And while it's not a Town and Country Planning Act case, so the development plan doesn't have primacy, it would still, in the council's view, need to be given significant weight as the most up-to-date land use policy framework in Scotland.
Thank you very much.
That's all they did. Yeah, no.
Mr. Herriot, is there anything you'd like to add to what you say in your statement or what Mr. Heinsohn has had to say?
No, I would agree exactly with what Mr. Heinsohn said about the significant weight to be given to the document. we are in that limbo period at the moment, albeit probably for the next 2 weeks or so only. And as you referred to at the outset, the Scottish Minister's letter from the 16th of January says exactly what weight they expect decision makers to be given to NPF4. So I don't agree entirely with Mr. Heindson's comments regarding this being a Section 36 role in the Town and Country Planning Act. Nevertheless, as the most recent expression on a national level of planning policy, it should be given significant weight, even at that decision-making level.
Okay, thank you very much. Secondly, I'd be interested to hear the views of parties on the nature of the change to planning policy in Scotland that NPF4 will bring about. Mr. Herrick, you highlighted paragraph 2.4 in your January statement, a difference of opinion between the applicant and the council on this matter. You say, and I paraphrase, that there should be no doubt that NPF4 marks a step change in the tone and status of Scotland's national policy. And then you go on to highlight that the council considers the requirement to give significant weight to the contribution proposals to renewable energy generation targets. And you say that's similar to the existing provisions of SPP. So, Mr. Herrick, can I ask you, is the change promoted by NPF4 fundamental? Is it more of the same, or is it somewhere in between?
It's the former, sir. It's fundamental. And we have the Minister's statement to Parliament on this very issue, where he said that NPF4 marks a turning point for planning. It's not a general policy update. And if we cast our mind back to the beginning of the NPF4 journey, the Scottish Government's intent was to rebalance the planning system so that the climate emergency, the nature crisis were pillars, if you want to put it that way, on decision making. And that's reflected in the ministerial foreword as well of NPF4, which says that putting the twin global climate and nature crisis at the heart of our vision for future Scotland will ensure decisions we make today are reflected in the long-term interest of the country. So it's a key change, without doubt. It doesn't represent a continuum of SPP. There are some similarities, for example, in some of the renewable energy criteria that we use to assess applications between paragraph 169 of SPP and policy 11, which we'll touch upon later. But it's the weight to be given to certain considerations in the planning balance that has significantly changed. So the climate emergency and the nature crisis really are the founding pillars of NPF4, and that's evident right the way through the objectives, the outcomes, the policy intent, and the policy wording.
Thank you. Heinson, your thoughts on this matter?
Yes, of course. In relation to the policy wording of SPP and NPF3 moving to NPF4, the policy wording has absolutely changed. There's no doubt about that, and the weight to be given to the climate and nature crisis, as well as the weight to be given to the contribution towards energy targets and greenhouse gas emissions. That is clear in NPF4. It is different to what it is in SPP. However, what I'd say is that in relation to how SPP and NPF3 had been applied in the latter days of their policies, significant weight was still being given to the climate emergency and the nature crisis and renewable energy targets through the decision-making processes by both reporters and Scottish ministers and by Highland Council as well. So while the policy wording has definitely changed, the way in which the policies applied, it may be a bit more subtle a change rather than necessarily the step change that's been suggested.
Thank you. Any further thoughts, Mr. Herrick, on what you've heard from Mr. Heinson?
Yeah, so
Saying that, excuse me, the pre-NPF4, certain reporters have given significant weight to these matters. in applying SPP and NPF3. That was a matter of choice. That was down to the individual decision maker's discretion. And the change we have now with NPF4 is that through policies 1 and policies 11, decision being told for the first time as a matter of national policy that they must give significant weight to the benefits of proposal in terms of greenhouse gas emissions, renewable energy targets, and the nature crisis. So I think I used the room. There's no room for manoeuvre. Pre-NPF4, there was room for manoeuvre. There was discretion. With NPF4, we've been very clearly told that significant weight has to be given to these issues. And that is actually amplified through the onshore wind policy statement, which we'll no doubt come to later on.
So may I add to that, that an example of what Mr. Herriot is saying appears within CD 1057, which is the report of the Rothers 3 inquiry by reporter Mr. Seaton. And it's worth, I think, looking at paragraph 2.181 on page 58, internal page 58 of that report, electronic page 60, where I think it's just worth reading his words because they say it very well. He's talking about the planning balance, and then he says none of this, and this being the changes that have happened with energy policy and energy report, suggests there is not still a requirement in terms of SPP to ensure the right development in the right place, or that there is no need to consider the adverse effects of onshore wind development or to balance them against the benefits. This is plainly still required. We refer to the specific requirements to strike such a balance in respect of landscape and national energy policy. However, the urgency of meeting those stringent targets, that's the net zero targets, set with the purpose of avoiding dangerous climate change, must necessarily affect the balance to be struck. This is so for every development. And so he goes on and then says, we acknowledge this is a different view than the position one of us took in making recommendations on the proposed Galty Clay wind farm. However, it appears to us that the evidence of the need for new onshore wind development in particular has moved on since that report was made in early 2020. So that is evidence of what was coming, and now it has come through NPF4 and been formalised in the way explained by Mr. Herriot. We got that name right at least. Thank you very much.
Thank you. Mr. Finlay, Mr. Heinson, I think you'd like to say in response.
I will, first of all, by all means, have regard to the report in Rothers 3, but the actual decision from ministers doesn't endorse those paragraphs that Mr. Trinick has referred to, not specifically as far as I read it. So that's 1057 is the inquiry report, the decision letter is 1056. But both Mr. Trinick and by reference to Rothers 3 and Mr. Herriot bear out in our submission Mr. Heinson's point that in terms of certainly Highland Council's approach to decision making and why it's here objecting to this wind farm is not impacted in essence by the change to that has been wrought by NPF4. Whilst Mr. Herriot said the freedom the freedom a decision maker may have had before to give less than significant weight to the climate emergency and the like is not one that Highland Council took advantage of. In fact, the contrary, as appears, for instance, in its statement of agreed matters and its officer's report. So, and certainly in our experience, almost universally, every reporter gave significant or very significant weight to the climate crisis. And we will make more detailed submissions on Mr. Seaton's particular approach in our closing submissions. There are matters of detail which I think would not be sensible to take up time with this morning.
Okay, thank you. Okay. Is there anything further to be said on that point, or can I move on? Mr. Trinick, anything further to add? Okay, thank you. The further general matter I'd like to briefly discuss is the presumption in favour of development that contributes to sustainable development. Mr. Herriot, you dealt with this matter in your original October hearing statement, noting that the applicant draws strong support from the presumption as set out in SPP. You refer to it again in your December statement and note that the presumption does not feature in the sort of the draft NPF4 at that stage, adding that its omission is not significant as NPF4 contains even stronger and more clearer policy support about the weight that should be given to addressing the climate and nature crises when assessing applications. And I wonder if you could just elaborate on what you say at paragraph 2.6 of your December statement and perhaps direct me to any particular point that you were referring to in NPF4.
Sorry, is that 2.6 of the December hearing statement?
December statement, yeah.
Well, let's not pull that up. I'm just reading that again. So that's the one that says the presumption in favour of development that contributes to sustainable development does not feature in NPF4.
That's correct.
Yeah. Okay. So so that's a notable change between SPP and NPF4, and as I acknowledged there, we don't have the presumption any longer. As far as renewable energy developments are concerned, the notable absence of the presumption isn't something that I think will have a significant or should have a significant effect on decision making. The presumption was something that decision makers grappled with, I suppose, in what it actually meant in practice. And that evolved over time in relation to housing developments and energy developments and other types of developments. But what we have here specifically in relation to renewable energy developments is a very clear, much less ambiguous statement in Policy 11 in particular about the need to give significant weight to the renewable energy benefits of a scheme. And that goes hand in hand with Policy 1, which is the overarching policy for NPF4, which also deals with the nature crisis and again tells decision makers they should be given significant weight to the benefits of a scheme in combating the nature crisis too. So we have two policies which, in my view, provide decision makers and practitioners with much clearer advice on what they should do with these two issues in the planning balance relative to what was at the time when it came out a more vague statement about what the presumption in favour of development that contributes to sustainable development actually means. And it's much easier to say as well.
All right, thank you. Yes. Okay. Ms. Heinsohn, I have a couple of questions for you on this matter. You conclude in your December statement at paragraph 3.1 by saying that draft NPF4 has taken the presumption, promoted it within a formal policy framework. And I just wonder if you're suggesting that in practice there will be little change in the way that decision makers approach the assessment of applications and their contribution to sustainable development, notwithstanding the provisions that are set out in NPF4.
No, I think it would be appropriate to say that the presumption in favour of sustainable development, as Mr. Herriot's set out, has effectively been removed, and it has been strengthened by the weight to be given to the climate and ecological emergencies. But still, there needs to be consideration of other matters related to sustainable development, such as social and economic factors as well. But that's covered elsewhere in National Planning Framework 4. But it's the weight to be given to such matters. It's significant weight needs to be attached to it, but that doesn't necessarily mean that other matters can't necessarily trump it in due course, depending on the specific characteristics and impacts of the case.
So could I perhaps add to that?
Yeah. Yes, Ms. Finlay, yes.
The removal of the presumption of favour of sustainable development, it obviously goes far wider than dealing with applications of the type you're dealing with today. So in terms of broad generality, does it make a difference? In one sense it does, but there is, if one looks at page 4 of under spatial principles of the revised draft, there's still the principles and practice are meant to be applied to achieve sustainable development. So whilst there's a change in the, and that's just one example of where sustainability comes within the document, but whilst there may be a change in the mechanism, certainly in our submission, the overall goal of achieving sustainable development and promoting sustainable development remains the same. It's just a different approach to it. And if then in terms of looking at this type of application in particular, that can be demonstrated by the types of matters that both Mr. Heinsohn and Mr. Herriot have referred to in terms of the specific support for renewable energy. So whilst it is a noticeable difference in the wording, whether there's a real difference in intended or actual outcome is another matter. And I say that looking with a broader perspective than just a wind farm development.
Thank you. Mr. Trinley, do you want to respond to that, or?
I'm happy to take that on, sir.
Yes.
I would agree with Mr. Finlay in as far as saying that the end goal, if we want to call it that, the achievement of sustainable development is very similar between NPF4 and SPP. And what does sustainable development mean? And that will be different things in terms of different applications. And for example, housing development might be different from renewable energy development. But what we have here is very clearly in the shift in emphasis about how we actually get to that end goal. And the policies that we've referred to, policies 1 and policies 11 in particular, very much strengthen the hand in terms of renewable energy development, saying, and as a contributor to the achievement of sustainable development, we should, as decision makers, it should be giving significant weight to these key issues. That was absent previously. And that's where I see the shift. The outcomes point is very important as well, because we do have the 6 outcomes set by the 2019 Act that NPF4 is required by law to contribute towards, and I've commented upon that in previous hearing statements. And the relevance in particular of outcomes E and F and the degree to which this development contributes to those. But what we actually have for the first time in national policy is individual policy outcomes and policy intent. And I think that's very important to take a step back as we look at policy minutiae and think, well, actually, what's this policy trying to achieve? And I think it's the first 12 policies of NPF4 are set out in green colour under the Sustainable Places heading. So those first 12 policies, in my view, are geared towards achieving the sustainable places outcome. There's livable places and productive places. But it's the means by which we get there has changed, and the emphasis upon the significant weight to the climate emergency and nature crisis that really has come to the forefront in NPF4.
So can I just add to that I detect a theme going through the Highland Council hearing statements and in what is being said this morning, that NPF4 represents an evolution from SPP, and it's an evolution which has been respected by Highland Council and by reporters prior to NPF4. I think it's very easy to get sucked into looking at the detail and saying, well, yes, certain words have changed, emphasis have changed, but it's just going to miss the headline point, as announced by the Minister in his closing speech to Parliament, that NPF4 is a radical document. It represents a step change. For the first time, we've had the defined twin themes of the climate crisis and the nature crisis. We have an entirely different spatial approach to renewables in comparison with SPP. And for the first time through the OWPS, that is linked to targets for onshore wind. So don't let's get too sucked into looking at the detail of the wording and forget what lies behind the intent which lies behind NPF4. And that intent is dramatically different from the intent which lay behind SPP and must be recognised in the application of NPF4 to projects.
Thank you. Jumping back, Mr. Finlay, or are you?
Well, I think I can understand why Mr. Trinick wishes to concentrate on the headlines and not the detail, but I think you have to have regard to both. And the NPF4 is a radical document for many reasons, some of which are entirely effectively unrelated to this inquiry, and that it becomes part of the development plan. But in our submission, in order to apply it appropriately and to understand the nature of the change affected as it applies to this type of application and this particular application, is necessary to have regard to the detail as well as the headline.
Thank you.
I think it's the two people with
Final general matter that I wanted to explore with you both is the significance of the requirement to deliver on the United Nations Sustainable Development Goals and to achieve sustainable development. These are referred to in Part 3, Annex A, on pages 94 and 95 of the document. And it states that the National Planning Framework plays a key role in supporting the delivery of Scotland's national outcomes and the UN's Sustainable Development Goals. And Mr. Herrick, we've kind of touched upon some of these themes already, but how significant is the requirement to deliver on the Sustainable Development Goals in my consideration of this application?
I think it's absolutely crucial, sir, because as you've referred to, page 95 of NPF4 highlights that the document is required by law to contribute to 6 outcomes. We've got housing needs, health and well-being, population of rural areas, and the last 2, meeting the reduction targets of greenhouse gases and securing positive benefits for biodiversity. I would suggest those are the 2 of most relevance to this application. And without rehearsing details that have already been submitted, we believe we contribute strongly to both, not just through the significant renewable energy generation, but also the environmental enhancement and biodiversity and peatland restoration proposals that go alongside this proposal. And you can looking to see how those national outcomes can be achieved. I think what NPF4 usefully does is provide individual policy outcomes. So when you're looking at individual policies, you can say and consider how a proposal would contribute to an individual policy outcome, which in turn can help deliver the national outcomes, which are, as I said earlier, are set in statute by the 2019 Act. So I think consideration of detailed policies needs to be brought back in the final planning judgment to actually how does this proposal deliver on the outcomes.
Mr. Heinsohn, do you have any kind of thoughts on this particular matter?
Largely similar to Mr. Herriot. I think we described it just at the end there about considering the policies in the context of the outcomes is important, because we have the policy outcomes and intent. In any case, I think that assists. I think rather than necessarily applying the weight to the matters as you bring them through the policies, and then separately the weight to the outcomes. I think it's important to consider them as Mr. Herriot set out there, together rather than necessarily separating them out, because if you separate them out, there'd be a risk of double counting the benefits of a scheme.
Is there anything, Mr. Trenick or Mr. Finley, you'd like to have? Okay, thank you very much. Moving on to consider part 1, the National Spatial Strategy. NPF4 describes the National Spatial Strategy for Scotland and 6 spatial principles around which future places will be planned. I didn't want to go through each one in turn, but rather I'd like to focus our discussion on the principle of just transition and explore its meaning and relevance in this case. Mr. Heinsohn, at paragraph 2.2 of your updated December statement, you do make reference to the spatial principles, and you highlight the principle of just transition, and you then rehearse what NPF4 has to say under that heading. But you didn't relate it to the application in any way. And I wonder if you could explain to me what you consider just transition to mean, why you chose to highlight that particular principle in your statement, and how it relates, if at all, to the consideration of this application.
So in relation to the just transition related to this application, the just transition, and it comes through the draft Scottish Energy and draft Scottish Energy Strategy and Just Transition Plan, the need to move very quickly away from the oil and gas industry, and this development, if approved, would facilitate that in part because it would potentially create jobs in relation to delivery of renewable energy. So there's transferable skills from that industry. So there is some benefit there, but the detail of how the scheme could assist in transition in the just transition in relation to the economic side of matters and that transition to net zero is set out in the environmental impact assessment report of the applicant in the socioeconomics chapter.
Thank you. Mr. Herriot, you also refer to just transition in your updated and supplementary statements. What do you consider the term to mean, and how does it relate to this application?
I think if we look at there's actually a definition in the glossary of NPF4. It's very brief, so if you don't mind, I'll read it out. It's on page 151. The definition there of the just transition is ending our contribution to climate change in a way that is fair and leaves no one behind. And I suppose that can be interpreted in a number of ways. Firstly, the reference to the climate change, to me, that means making strides to meet our legally binding net zero targets by 2045, with significant progress by 2030. And it means that on that path, decisions about new developments need to be, and policy formulation should be informed, so no one is left behind. That can mean everything from pre-application consultation and application stage, involvement in arenas like this. As Mr. Heinsohn says, it can also mean about socioeconomic factors, and the onshore wind policy statement in the energy strategy do talk about the transition away from oil and gas, and they refer to the transferable skills, and I would agree entirely with that. And I think it's also slightly broader as well, and it brings in issues such as energy security of energy supplies, and that's a key theme that has much greater focus, I suppose, in the last 12 months for obvious reasons. And that does refer to reducing our exposure to more volatile external energy markets, and the impact that has had upon energy supply and consequently prices. So I would agree with what Mr. Heinsohn said, but I would take it a bit further, just looking at the definition in NPF4.
Yeah, thank you very much. Would you like to add, Mr. Heinsohn? Or you?
No, I think the comments that Mr. Herriot has set out is fair in relation to looking at that wider issues around about the just transition and people's involvement and how they shape their places as well. I think that's important for these types of developments, and as part of that, taking into consideration obviously communities' views on developments as they come forward as well.
Yes, so if I could add just a reference to support Mr. Heinsohn's point, if one looks at page 7 of NPF4, the commitment to just transition specifically notes that the journey must involve and be fair to everyone. And I think that endorses Mr. Heinsohn's approach to include the community in that too.
Thank you. Mr. Trinick, anything you'd like to say? Thank you. The next point I wanted to raise features in Annex B, which describes national development statements of need and their role in helping to deliver the government's spatial strategy. Again, Mr. Herriot, you discussed this matter in your December statement, noting that the proposed development benefits from national development status. I wonder if you could just say to me, what does this mean for my consideration of this application?
Sure. I think first point to note is that the difference between NPF3 national developments and NPF4 national developments. So for the first time, we've got energy generation developments 50 megawatts and above featuring as a national development, which marks a change from NPF3. I think it's a significant change. I think when you look at the language in the description of the National Development 3 on page 103, NPF4, it describes that these types of developments are fundamental to.
Yeah, sorry.
Would you like me to repeat that?
Yes, please. I was just getting my copy of NPF3. Sorry.
Yeah, sorry. So at the bottom of page 103 of NPF4, under the statement of need, this class of development is described as fundamental to achieving a net zero economy. And above that, in paragraph 2, it states a large and a rapid increase in electricity generation from renewables will be essential for Scotland to meet its net zero targets. So I think it's very clear that the scale and the type of development that we have in National Development 3 applies to this proposal. It differs from predecessor NPF3, and it's described by the Scottish Government in this document as a fundamental type of development to help achieve a net zero economy. And that's where I bring it back to the outcomes of Policy 11 and the outcomes as set by the 2019 Act. Of course, it doesn't mean that permission is granted, and we acknowledge that, and that's very clear on page 97 of NPF4. But national development status has to count for something in the development management context, and I'll maybe return to that point later.
Okay, thank you. Ms. Heinsohn, the same question to you. What does the status of national development mean for my consideration of the application?
So in terms of your consideration of the application, it means that it's supported in principle, but all of those relevant detailed matters still require to be considered to set out whether the proposal in itself, in its location, is considered to be considered to be acceptable in terms of all the other policies and all those other detailed considerations. Having a national development status appears to elevate a type of development because of the overall need for that type of development, but it's still that consideration of the particular matters related to the case, whether it be site and design, landscape visual impact on the on wider environmental factors and economics still needs to be considered. Being a national development doesn't trump that, as it's set out on, as Mr. Herriot referred to, on policy page 97, sorry, of NPF4. And we've had energy developments in National Planning Framework 3 as national developments. We had the pumped storage schemes, pumped hydroelectric storage schemes as national development, and they were set out because of the intermittency of supply of certain types of technologies. But there is a slight difference in the way in which need is described on these types of projects between National Planning Framework 3 and National Planning Framework 4.
Can I just add in respect to on this topic, and I think you received an email from Karen Lyons yesterday that in respect of pumped storage, we've provided, or I don't know whether you've formally accepted them yet, but we proposed to provide an example of an inquiry report and decision letter on pumped storage, because it arose from a similar session yesterday on Cairndui wind farm, where the reporters asked a question about along very similar lines to which you've asked today, and how it works in practice, in particular how it relates with other policies. And it's a generic form of national development, it's not site specific. It's so pumped storage and renewable energy are both generic in that sense. And so it was thought to assist you. I know Mr. Trinick didn't object to it yesterday. I don't know whether his position has changed overnight, but we simply put those forward as some assistance to you in that regard, because renewable energy being a national development hasn't been considered before, whereas it has as being part of pumped storage.
Yes, I did see the email yesterday, and I was happy to accept the additional documents. Mr. Trinity, anything you want to say on those on that matter?
No, sir. I'm happy that the document comes in. We can deal with it and closing submissions perfectly happily. I just note that while pumped storage and energy may have been national developments with NPF3, the drivers behind NPF3, and I refer to what I said earlier, were very different. The drivers behind NPF4 refer again to the twin themes, etc., etc. I won't go into detail.
Okay. Thank you. We've touched upon this particular matter, but I wanted to discuss briefly the national outcomes listed on page 95 of NPF4 and their status and how the proposed development would contribute to their delivery. I can start with you, Mr. Herriot. I appreciate you've touched upon it, but what is your understanding of the status of the national outcomes as expressed in NPF4? And how would the proposed development contribute to their delivery?
Yes, there's 6 outcomes, as I've already alluded to, which are set by the 2019 Act. NPF4 makes it clear, I think it's page 95, that NPF4 is required by law to contribute to these 6 outcomes. So it's effectively the tool to ensure that these matters are delivered, and that runs everything through from housing needs, which is not relevant to this application, down to items E and F, which relate to reduction of emissions, greenhouse gases, and securing positive benefits for biodiversity. So those 2 national outcomes are directly relevant to this application, and for the reasons I've set out in previous hearing statements, we believe the proposed development contributes strongly on both fronts, both through the renewable energy generation and the significant restoration, peatland habitat, and wider environmental measures set out in the applicant's submission. And I think it's also useful as well, because we now have the benefit of NPF4, to look at the individual policy outcomes. At the risk of repeating myself, that is the first time we have got stated policy intent and policy outcomes. And I think it's very important to take a step back when we've assessed the detail of the policy themselves, the extent of compliance, and say, how would this development contribute to this individual policy outcome, and the extent to which it would contribute to the national outcomes. So there's two sets of outcomes to look at, one of which the six benefit from significant weight in the 2019 Act.
Thank you. Mr. Heinsohn, I know you don't refer to the national outcomes in your statements, but is there anything you'd like to say on this particular topic?
Not dissimilar to Mr. Heriot's views on this matter. They do need the two most relevant ones are ENF, and it is I agree with them that the policy outcomes as well are important, but obviously those policy outcomes have to be considered. You've got to consider the detail as well as in terms of the detail of a proposal against the details of the policy, to consider whether the policy outcome can be achieved by that particular development. Obviously, say if we're looking at policy 11, for example, by granting consent, it would be obvious that you would meet the policy outcome of policy 11 for the expansion of renewable, low carbon and zero emission technologies. But it's the other considerations within that still obviously have to be taken into consideration in bringing forward schemes.
When you get one back and they're just hold on, then you're like, yeah. Oh no, it's fine. Yeah.
Mr. Trinick, Mr. Finlay, is there anything you'd like to add before we move on from part one? Okay, thank you. Okay, now turning to part two, national planning policy. Both parties list policies considered pertinent to consideration of the application, and I wanted to focus on policies 1, 3, 4 and 11. I was intending to deal with them in numerical order before opening up the discussion to consider other policies that may be relevant in this case. So policy 1, tackling the climate and nature crises, states that when considering all development proposals, significant weight should be given to the global climate and nature crises. Mr. Heriot, in your December statement at paragraph 2.43, policy 1 makes clear that there is no longer any discretion about the weight that should be given to these matters in the planning balance, and that this marks a notable and significant shift from current national planning policy. And then you reiterate the point in your January statement. I mean, how significant is the change set out in policy 1 from that of NPF3 and SPP?
It's a fundamental shift. The policy makes it very clear. Policy 1 deals with two issues. It deals with the extent, it's an overarching policy, I should say. So it's not renewable energy specific. It relates to other land uses as well. And it tells decision makers that they must give significant weight to the contributions to A, the global climate emergency, and B, the nature crisis. So it's overarching in that respect. And as we've already discussed, so some decision makers have given significant weight to some of these issues in previous decisions, most probably the contributions to the global climate emergency, maybe less so to the nature crisis. And I think that's an absolutely fundamental shift. Now, that if any decision maker that didn't give these two issues significant weight would be deviating from the very clear instructions in this new national planning policy document. And I go back to what the minister said in his speech to Parliament a few weeks ago, that NPF4 represents it's a turning point. It's not just a general policy update, and it's a turning point in as much that the global climate emergency and the nature crisis really are the pillars on which NPF4 has been founded. And Policy 1 has been drafted to make sure that those two key considerations are at the forefront of decision makers' minds on all applications, not just renewable energy proposals.
Thank you. Mr. Heinsohn, you also touch upon this matter at paragraph 3.4.5 of your October statement. Can I ask you the same question, please? I mean, how significant is the change promoted by NPF4 through Policy 1 from that of NPF3 and SPP in terms of the weight to be given to global climate and nature crises?
In terms of policy wording, absolutely, it is a significant shift in policy wording. It quite clearly needs to be given significant weight. There's no doubt about that in the policy. What I think is important, though, is that while it needs to be given significant weight, it's not weight beyond all other considerations. I think that is really important. And then it comes down to what weight as a decision maker is given to those other matters, and that can only be determined on a case by case basis. I think, as Mr. Herriot set out, it's important that it's considered on all applications, not just renewable energy, and I think that is very, very important. And absolutely agree with what Mr. Herriot said. Well, we discussed earlier, and I put across the point that in other more recent decisions before NPF4, significant weight had been given to the climate emergency. There hasn't been much weight, if anything. I've not found a decision yet that raised the nature crisis as a significant consideration. So that is a very much a significant shift, and not just in terms of wording, but also in terms of the onus put on the decision makers going forward to consider such matters.
Okay, thank you.
Perhaps I could just add to that, reiterate one point, that
Please do.
It clearly accept that it's a significant change in policy wording, but whether that translates into a change in policy approach is a matter that Mr. Heinsohn and I have already touched upon, may do to some people, but not to decision makers or Highland Council. Endorse what Mr. Heinsohn said about the elevation of the global nature crisis, and that may be relevant, particularly when we get on to Policy 3, biodiversity and other matters. And just note finally that it says significant weight. It doesn't say very significant weight, it says significant weight. And no doubt a matter will be touched on in closing submissions. There tends to be an argument about what significant means in that context, and you could get to the heads of how many angels you can stand on the tip of a needle. It's noticeable both here and I think in Policy 11 that the drafters of NPF4 have just opted for the word significant weight, not very significant weight or more significant weight than before, but significant weight, and then leaving it to the decision maker to balance that with anything else. That's not of itself a change in approach. It's definitely, I don't wish to undermine what I said about policy approaches before, but it's it should perhaps give decision makers cause for thought by trying to calibrate or various aspects of significant weight. It is significant weight. If you give significant weight to it, you are complying with policy.
Mr. Trinick, would you like to? Please do.
Yes, well, we tend to run out of words, don't we? The word significant is thoroughly overused, and we struggle to find an alternative. I'd rather put it this way, that what policy 1 is saying and what the policy balance in policy 11 is saying is that these factors, the global climate and nature crises, are very important indeed. And I refer to what Mr. Herriot has already said, that these two crises are the twin pillars of NPF4. That is new, and I think that gives additional weight to the word significant weight, which are overplayed, but nevertheless, the words that he used, they give additional warmth to those words in policy 1 and policy 11. Warmth is a good word, I think.
In this week, sorry, can I just make one final point on this, which may assist your considerations about this whole issue about what significant means, and it's slightly getting ahead of the game, but it's the onshore wind policy statement.
Yeah.
And paragraph 3.6.2, and in that section, the discussion relates to NPF4. And the last sentence on 3.6.2, it says the criteria for assessing applications has changed and been updated, including stronger weight to be afforded to the contribution to the climate emergency. So I think that's a useful relative term, stronger than has hitherto been the case. And the OWPS concludes with the comment that the onshore wind is mission critical to meeting the climate targets. And I think that's maybe useful context to actually refine what we mean by significant weight.
Yes, we'll be coming on to talk about the onshore wind policy statement later. But before we leave this topic, is there anything you want to come back on there, Mr. Finlay, Mr. Heinsohn?
Yeah. Could I come back? Sorry, I'll jump in before Mr. Heinsohn does. Just on 3.6.2 of the OWPS, that is referring to the draft NPF4, and the criteria have been updated, including stronger weight being forwarded to the criteria to the development to the contribution of the development to the climate emergency. That parties are agreed on, that the wording has been strengthened. There's no doubt about that. I think Mr. Herriot tries to stretch too far in using the word stronger weight there to add, in specific terms anyway, meaning to significant weight in policy 1. And secondly, to say that I look forward to the word woomph appearing in NPF5. But we understand what Mr. Trinick's getting at, and there's a to be fair to him, there's an underlying reality in what he's seeking to portray by that word. So I don't go behind that, but I do say, but I do rely on my previous submissions as to significant is not it means what it says and is not further described by very significant or otherwise in the policy. And with that, I'll pass over to Mr. Heinsohn.
Nothing further to add. The points that I was going to raise has been raised by Mr. Finlay.
Okay, thank you. Anything further, Mr. Trinick? Staying with policy 1, Mr. Herriot, do you have a view on whether the intentions of policy 1 should be met in equal measure, or could a proposal meet one but not the other?
I think a proposal could meet one and not the other, and equally could meet both. The key point being that policy 1's an overarching policy. So, for example, a housing proposal might be more inclined to help address the nature crisis through, for example, the layout of a development, the inclusion of biodiversity areas, species in hedgerow planting, etc., and maybe less of a contribution, a direct contribution, shall we say, to the global climate emergency. And that's why we've got the other policies, in this case, policy 11, which is more directly relevant to this proposal. So it is possible for proposals, as we have here, to meet both of them, both objectives, and equally other proposals that can maybe meet one or the other. You may well have a renewable energy scheme that comes forward that maybe doesn't quite tackle the nature crisis to the extent that this proposal does with its restoration and peatland habitat proposals. So it might satisfy one limb and not the other.
Okay, thank you. Mr. Heinsohn, same question to you.
There is no difference between myself and Mr. Harriott on this matter.
Okay. Is there anything further to say about policy 1 before I move on? No? Okay. Well, moving on to policy 3, this deals with biodiversity. Mr. Harriott, your January statement contains some additional commentary at Appendix 1 on ecology and ornithology matters to demonstrate the application's compliance with policy 3. Firstly, I wanted to check that the applicant isn't proposing any new environmental enhancement measures, and that you're simply presenting the material in a way that's perhaps to aid a better understanding of what is being proposed. So can I just check that point first, please?
That's correct, sir.
Okay. Okay, staying with you, Mr. Harriott, I wonder if you could take me through what you say at paragraph 210 of your January statement and the additional commentary at Appendix 1.
Yeah, because I had to leave the room.
I'm just getting to that relevant paragraph.
Yeah, sure.
They may be dead.
Okay, so that paragraph is where I was commenting upon policy 3 with the benefit of the additional commentary in Appendix 1, effectively summarising the nature of the applicant's restoration and environmental enhancement works and considering those in how they would help achieve the objectives of policy 3 and indeed the policy outcomes, and summarising the degree to which these works could be described as enhancement rather than just mitigating the effects of the development, summarising the intention, the recovery rates proposed through the habitat management proposals, the extent of the area, geographically it's 131 hectares that's proposed for peatland restoration, and a summary of what is proposed in the habitat management areas and how those management regimes and changes to them would have benefits for golden eagles as well as peatland restoration. So it's a summary really of the nature of what the applicant's proposing with reference to Appendix 1, and what we do ultimately say in terms of the policy 3B in particular, where there's this requirement to demonstrate that nature networks are in a demonstrably better state than without intervention. The Appendix 1 was ultimate to try and take that forward. We don't have a metric yet for measuring pre and post intervention. What we're saying is that Kintradwell, in many respects, was ahead of its time in that respect. It was proposing measures to enhance the habitat, and through that and through the creation of a habitat management group, for example, the habitat management plan, when it would be approved post consent, hopefully, would be a live document, would be subject to review. So, for example, if something came through the draft biodiversity strategy, that could possibly reflect in updates to the HMP.
Okay, thank you.
That would not be done in that.
Is there anything you'd like to say about policy 3, Mr. Heinsohn, at all?
Have a look and see.
Just briefly, it is helpful that the information has been pulled together in the appendix for yourself to consider what the benefits are of the scheme. You have to appoint a baseline for the environment within the environmental impact assessment report. As Mr. Herriot set out, there isn't a metric necessarily with values attributed to the current state of the biodiversity across the site or the wider area, indeed, in which the proposals will be, the enhancement proposals are set out. But it does give you an opportunity to measure that. However, while Mr. Herriot has set out that it's Kintradwell in a way is ahead of its time in terms of policy, I would say that's maybe going a little bit further than I would have, because what is put forward are generally good practice measures that are brought forward through a number of wind farm applications and have been done for a number of years. But I think it fits with the policy context as it is now set out. And I'm aware that there's matters in there and the opportunities for review, and they're all proposed to the conditions which have been agreed. And I'm aware that Loth residents had concerns with regards to ornithology, and so that would probably be relevant in your consideration of the matters of biodiversity in relation to ornithology and any enhancements that could be provided in relation to ornithology. And in policy 3, we have that word significant once more. So it has to be significant enhancements as well.
Okay, thank you.
Without the metric, that in a way is difficult to demonstrate, but it's not impossible.
Can I say that Loth residents will be responding in their closing submissions to this, not playing a part today?
Okay, thank you.
Go and run that date by me again. Nah. It was we were away. I was away in Thurso for the. Oh no, that was the week after.
Okay, I've got a couple of questions on policy 4. I was going to suggest perhaps we.
So just to finish off on policy.
I beg your pardon, Mr. Trinick. Yes.
Policy 3, if I may just add. I don't completely agree with Mr. Heinsohn when he says that what we are proposing simply reflects good practice. It is fair to say that there has been the writing on the wall for some time that wind energy developers, especially those of large proposals, would need to be more mindful of biodiversity than they have been to date, and to start introducing enhancement as opposed to mitigation. I think Kintradwell is a leader in this respect, that it has successfully anticipated policy 3 by providing not merely for the effective mitigation of impacts, but also building in substantial enhancement proposals. So I think it is ahead of its time. But as Mr. Herriot has said, we don't yet have a Scottish metric. We just have the UK metric, which doesn't work very well up here. But we also have the Chief Planner's letter, CD 625, which talks about transitional arrangements. So this is one of those we are in transition between one system and another, and a metric will emerge in due course. There is a working group which has been set up through Nature Scot to establish a new metric, and it's important that the condition which is imposed on any consent which is granted for this wind farm reflects the transition which is taking place by allowing flexibility in the development of the programme going forward. Thanks, sir.
Thank you. Henry, would you any further comment on policy 3?
I hear what, just to respond to what Mr. Trinick says, I think I prefer Mr. Heinsohn's approach that it's what's been provided is good practice rather than being ahead of its time. But that will no doubt be dealt with in closing submissions.
Okay, thank you. I was going to just ask a couple of questions about policy 4, and then I was suggesting we might take a break. Is that okay? You see from the hearing statements, there's some disagreement on the application's compliance with policy 4. The council notes at paragraph 211 of its December statement that due to the proposed development's impact on the special landscape area, it would fail to satisfy the first criterion of the policy. The applicant takes the contrary view on this matter. And Mr. Herriot, at paragraph 216 of your statement, it says that the council's comments regarding the second criterion are unclear. And neither of you actually mentioned clause D of the policy, but I am presuming that we are talking about clause D of policy 4. So Mr. Heinsohn, you say that the second criterion reflects the terms of the Highland-wide LDP policy 67 and requires a balancing exercise to be undertaken. I wonder if you could say a little bit more about that and explain what that link is between NPF4 policy 4 and the LDP policy 67.
So in terms of policy 4 and particularly section D of it, in terms of policy 67, it's the section, it's the third bullet point in policy 67 on visual impact and impact on landscape character of the surrounding area. And it sets out that proposal should seek to minimise landscape and visual impact, subject to other considerations it sets out. I think in terms of the detail of policy 57, the detailed consideration of special landscape areas, you're reliant on policy 57 of the Highland-wide local development plan, which identifies it as a local feature, and sets in the appendix where it defines the different types of features. You need to consider whether there is an impact on the integrity. I think what we reflecting on that though, considering what there is in policy 4D, it is a stronger test than what is in the local development plan. It raises the bar. It's a similar test to what we have for national scenic areas, rather than, but it's obviously reflecting on the benefits being clearly outweighed by social, environmental, or economic benefits of at least local importance. So while at least the way that policy 67, 57, particularly 57 really rather than 67, had been applied in relation to this matter before, NPF4, I would suggest that the bar has been raised by the wording in NPF4.
Okay. Can you just remind me, at the beginning of your answer there, you pointed me to a particular section of policy 67. I've got that in front of me now.
Yeah, it was the third, so in the subject to the balancing of these considerations section, so the third large paragraph, then there's the third bullet point down where it sets out landscape character of the surrounding area.
Thank you.
Yes, if I could just add to that.
Yes, please do.
Obviously, well, policy D does in effect three things. It provides that development will only be supported where, first of all, it doesn't have significant adverse impacts on the integrity of the area or the qualities. But if it does, then those significant adverse effects, it does say on the integrity of the area, but I think when we were discussing this yesterday, there was agreement between the parties that it should probably include integrity of the area or the qualities, because it otherwise wouldn't make the logic wouldn't follow through. is clearly outweighed by social, environmental, economic benefits of at least local importance. Given it's a national development, and I'll leave this for probably a following question, the second step may not be a difficult step to deal with. But then there's the third issue, that they have to be clearly outweighed. And that is if you like, a reverse tilted balance, or akin to some of the language that is in current SPP, which we'll be losing soon. But it's different, for instance, from the straightforward balancing approach that one might find in policy 4A, which is an overarching policy which applies that if there's an unacceptable impact, development will not be supported, to summarise. That's a straightforward balance. Whereas the balancing exercise in D2 is a weighted balancing exercise. Something has to clearly outweigh, and when one is applying it, you have to give those words their due weight and importance. And that's why we say, I support what Mr. Heinsohn says, that it's a strengthening of policies in respect of SLAs.
And the amount of times that the webcast broke. The webcast. It's like.
Harriet, your comments, what you've heard from the council, and your observations on policy 4 in respect of the application.
So I'll come in first to clear some things out of the way first. Firstly, we agree that D1 is a strengthening of the position on SLAs. Secondly, we agree that in D2, the word special qualities should be added to integrity. And thirdly, clearly outweighed. Well, that's an ultimate planning judgment. Simple as that. That's for you. And I'll deal with that in closing submissions. I'll hand over to Mr. Harriet, eventually, to deal with the remainder of this point.
Mr. Harriet.
Yes. Just going back to your initial points about the link between policy 4D and policy 67, and that was a query I suppose I had in my hearing statement when that it reflects policy 4 reflects policy 67, and the point I was trying to make in my hearing statement and reiterate it is that policy 67 is a more rounded policy. It's the wider planning balance. Impacts upon landscape and visual matters are one of the range of considerations within it. The ultimate test being whether or not a proposal is significantly detrimental overall. Policy 4D very clearly deals with local landscape areas only. And so there's a planning balance judgment to be applied within a wider planning balance. You can arrive at conclusions on policy 4D, for example, but you need to carry those through, in this instance now, to policy 11. What do we do with the conclusions on any conclusions you arrive in terms of the impacts upon the SLA? They need to be carried forward to the wider planning balance that's now set policy 11. So that's the first point to clarify any confusion between the links, but in my view, between policy 67 and NPF policy 4. We've heard what Mr. Trinick has had to say about the policy D1 and the increased weight to SLAs. I don't disagree with that. What I would say is that it still doesn't mean that if you conclude there's a significant effect on the integrity or indeed the special qualities of the SLA, that doesn't mean the proposal fails. We still have got to consider policy 11. Policy 11 tells us that proposals will be supported. There's no blanket ban on development within SLAs, for example. We've only got national parks and national scenic areas. So we've effectively got group 1 areas, if we want to use the SPP spatial framework terminology, and we've now got group 3 areas. We don't have the group 2 in between. So if you conclude that we fail policy D1, and there is an adverse impact upon the significant adverse impact on the integrity or the qualities of the SLA, you then pass to part 2. And for the reasons we have set out in our hearing statement, we feel that the benefits of the scheme are of at least local importance. What I should say is you don't have to demonstrate social, environmental and economic benefits of at least local importance. The policy uses the word or, so it's social, environmental or economic benefits of at least local importance. And I think this is where application of the national development status might well be of assistance. We talked about that earlier. What does the decision maker do with that in a development management context? And I think that's where this comes in. We've already said that NPF4 clearly sees this type and scale of development as being absolutely fundamental to achievement of the net zero goals due to its scale. And I think from that we can pull out that the environmental benefits in an energy context are of at least national importance. By definition, they're national development. On top of which we have got other environmental benefits through the peatland restoration and other habitat management improvements that we feel go beyond just local importance. And that's, as Mr. Finlay correctly said, that's a balance in itself. But we believe that the nature of this scheme tips those balance and that you can find they are of at least local importance.
So I just add to that before we pass over to Highland Council that we have to read Policy 4 with Policy 11. And in terms of the spatial framework in Policy 11, development proposals for all forms of renewables will be supported, but not in national parks and national scenic areas. But in all other areas, including SLAs, they will be supported. I think that point needs to be noted in the context of Policy 4.
Finlay, Mr. Heinsohn, would you like to respond?
Just in relation to the last point that Mr. Trinick made, in relation to Policy 11, yes, there is in principle support for renewable energy developments, and the spatial framework, yes, it's no longer there. It is the spatial framework, I suppose. What we've got now is Group 1 and Group 3 areas. If we were to relate it back, everything other than national scenic areas and national parks are now Group 3 areas. And in Group 3 areas, as it was, there was in principle support for such developments. But you had to consider all of the relevant considerations, and as part of that, special landscape areas and the impact on it would still play a part in that.
Okay, is there any further comment, Mr. Herrett, Mr. Trinicum, on that?
No.
Okay, well, thank you for your contributions on Policy 4. It's 11 o'clock now. Can I suggest we take a 10 to 15 minute break? 10 minutes sufficient, or yes? Okay, let's take a 10-minute break and return back at 10 past 11. Okay, thank you very much.
Yeah. No, yeah, getting used to that. It's definitely it's always
Oh,
yeah.
it's sometimes make going out to Creek for Christmas. It's
Yeah.
especially easier now that I've to kind of
Yeah.
start doing it's just that half hour,
Yeah,
40
it's not
minute
bad.
drive. So it wasn't too bad there at Christmas, but
Yeah.
I know that like God, but it's been snowing recently. It'll be much.
Oh,
kinda
yeah,
heavier up
yeah.
there.
But no, it's really nice. So just
Oh, brilliant!
finding all the places to eat and everything like that. It's nice.
Yeah, because Main Street isn't bad. It's just I think the big problem there is you have to kind of drive it if you want like a Tesco's or
Oh,
something. It's just a
Yeah,
It's
it's got so they built a big Aldi.
oh,
Yeah.
brilliant.
So down where the Highland Games was.
Yeah.
So along from there, there's a lot of new developments. That's what we're in there. There's a B&M and an Aldi now, so
Right.
can't argue with that.
Oh.
And then the newish primary school and high school is
Yeah.
along there as well.
Because I know, like, I think that was always something the locals were complaining about
Yeah.
ages
Well,
past.
I was chatting to Trevor when he told me when I told him I was moving there. He said years ago he gave Sainsbury's permission, but they never followed through. So what they were gonna do was build the Sainsbury's where the Highland Games bit was, and the Highland Games thing was going to move to a proper stadium that was all going to be built. But obviously never realised. But you enjoyed it, yeah. How about yourself? How you keeping?
Yeah, a lot of things going well. No, not too many.
Yeah,
Just
good.
yeah, just sneaking things at the house.
Yeah, the usual things.
It's
Yeah.
no the weather's not holding up for it.
Oh,
It's the shed I use for an outside gym.
right.
See, the big problem is it's too thin, dehumidified.
Yeah. Just
So, because it keeps in heat quite well, but ironically enough, it's like a car, so the condensation.
you get your squeegee out and that sort of thing.
Yeah, but the inside paint's kind of wet, so
right,
we'll need to repaint that.
Just give it a wee.
Paint in the arse try to get rid of the Christmas part.
Yeah.
Gym.
Sweat it out in there.
Exactly. So
Yeah.
it's work.
Yeah.
Yeah, aside from that, it's always like he's
Yeah. No. Yeah. So yeah, we've got NPF4 hearings every day this week. So yeah, that keeps going. And then all the in-person stuff starting to pick up again. Plus everything else. Yeah. So no, all going well. Cheers.
It's not a bad part of the world to get to.
Sure, it's nice.
Yeah.
Not regretting it anyway, which is good.
See if you're with stay in.
Yeah.
Sure it's in a place you actually want to kind of stay in.
Yeah.
Thing that partner kind of talking about because it's a two bedroom we're in at the minute. It's just a small house. It's like a semi-detached, but we're kind of like, to be honest, we want to try and wait it out and see what we're actually wanting.
Yeah.
Place longer term.
Yeah.
So that's kind of no make.
Yeah.
But
no rush.
No.
No, it's good.
It's only if we decide to.
Yeah. Get a bit more room. We banished that shed permanently. Yeah.
It's good.
And he's about to restart here, so
no
back on.
worries.
Cheers, thanks.
if I don't get the chance, if you see Tammy before she goes, can you ask her if she wants a mobile phone? And we'll need to do the setup and stuff, but it's just to confirm whether she wants it or not.
Where do you want these cables are using for this? Hydrogen? Don't want to take it.
No, just pop it in the cupboard. Yeah, and there's going to be another one of those. Seen another exchange for it.
Okay, welcome back. Are we ready to resume? Yep, super. Yes, the last policy I wanted to focus on in detail is policy 11. Obviously, this one deals with energy. And I'd like to focus on two clauses. Firstly, clause C and its consideration of net economic impact, and clause E, and that's regarding significant landscape and visual impacts. Now, the environmental impact assessment report sets out the economic benefits of the proposed development at a national and regional level. However, it's unclear whether the application has maximised those economic impacts. Now, I appreciate this is a new policy consideration, but I'd just like to clarify whether the headline figures that are set out in the EIAR supporting the application can be described as maximising net economic impacts, or do we need some further guidance, this transitional guidance that we referred to, before we can actually take a view on this particular matter? Mr. Henry, if I could ask you that question first, please.
I think, as you rightly say, the application was prepared and submitted before NPF4 came in. And the terminology has changed, including this word maximised. So there is a shift there. We've put forward in the hearing statements, as you say, the degree to which we think we have not quite anticipated that, but for example, the applicant's commitment to a local apprentice, funding a local apprentice in the area, the applicant's commitment to giving the local civil engineering firm first right of offer in the civil construction works associated with the job, go beyond what I would describe as the standard package of economic benefits that go with a wind farm, whether that be community benefits are not relevant, material consideration, but in terms of job creation and spin-off effects. So I think we've done what we reasonably should have done in terms of maximising the benefits before this policy's come out. What is important on your latter point about further guidance, there is guidance coming out on this very issue, and that's referenced in the onshore wind policy statement. in paragraph 5.2.4. Bear with me a little second, I'll just read that to you. And again, this whole issue about us being in a bit of a transition, and that refers to Renewable UK and work they're doing to fully understand supply chain opportunities in Scotland. This report will be published shortly and useful to inform the approach to maximising supply chain benefits. So I do expect, because of the shift in this, we will see further documentation published in due course.
Okay, but from what you said there, it'd be essentially you're saying that even without that particular sort of consideration of maximising, what the applicants are proposing is gone beyond what one might reasonably expect, an applicant to do. You've explored opportunities that perhaps other applicants may not do. Yeah.
Yes. Yeah.
Mr. Heinsohn, you addressed clause C at the beginning of paragraph 2.9 of your December statement, but you don't relate it to the application specifically. I wonder if there was a particular point that you wanted to make on this matter.
I think really just kind of following up from the question that you put to Mr. Herriot. I think yes, we do need that additional guidance. It is coming through the sectoral deal as well, which is highlighted through the onshore wind energy policy statement, which Mr. Herriot's taken you to. It is a new concept, the maximising the economic benefits for onshore wind anyway. For offshore wind, it's something that has been in place for some time, but so there may be something that you can draw from that, but we've not got any decisions on the core document list with that in consideration. What we have had for a number of years, though, is Section 36 cases and applications coming forward where there have been memorandums of understanding between applicants and contractors or ports of entry and things like that, where it's set out that yes, they will use those particular ports or contractors and give them first refusal, and there's usually a number of clauses to that, without examining the detail of it in particular for Kintradwell. It's just to highlight that we have had that kind of approach taken on a number of wind farms in the past, where they have set out that they will use local contractors and things. And yes, sometimes that comes to fruition, other times it doesn't. But not to go into any detail or not to suggest that it wouldn't happen in this case, but it's something that we have had over the years on a number of different cases.
Thank you. Is there anything that Mr. Trenick or Mr. Finlay you'd like to add to the discussion on this particular point? No. Okay. Okay, turning to clause E, and the range of factors to be considered in the assessment of renewable energy proposals. I'm interested to hear the views of the parties on what they consider the main changes to be from those set out in paragraph 169 of SPP. And in particular, what clause E2 has to say and its relevance to the application. Mr. Herriot, you deal with this matter in your December and January statements and make particular reference to landscape and visual effects and the mitigation measures that are embedded in the design of the proposed development. And Mr. Heinsohn, you deal with this at paragraph 2.10 of your December statement. You both highlight the use of the conjunctions and or together in the last sentence of the clause. So start with you, Mr. Herriot. Could I have your general observations on clause E2 and the use of the and or in the final sentence, which I note you say is a significant point?
Yeah, sure. I think before we move from E2 specifically, it's worth maybe just reading the first bit of E itself. That then set the context for points 1 right the way down through to 12, and it says, in addition, project design and mitigation will will demonstrate how the following impacts are addressed. So it's saying to developers, as part of your application, we're expecting you to demonstrate how you have addressed these various factors, one of which is how you've addressed potential for significant landscape and visual impacts. And at a very simple high level, that is addressed in the environmental impact assessment report, in the alternatives chapter, for example, which explains the design evolution of the scheme from initial concept through to application, and how landscape and visual impacts, amongst other matters, have been considered between various turbine layouts and movement of turbines to try and minimise the effects as far as possible. So that's dealing with that first point. The second bit is, and specifically in relation to the question about the and or, I very much see that as the policy is not expecting developments to have localized impacts and appropriate mitigation to have been applied, although they possibly do go in hand. If you apply appropriate design mitigation, it may well be that you end up with impacts that are localized. But that's the second limb of the policy. The first limb is recognizing that significant landscape and visual effects will arise or can arise from renewable energy developments. So that first point of recognition, which is important. And then it says where these impacts are localized, they will generally be acceptable, or where they're localized and or design mitigation has been applied, they will generally be considered to be acceptable. And I think the final words are important. They're generally considered to be acceptable. The expectation, I would suggest, is that where we can demonstrate these are localized, it would be unusual for them to be deemed unacceptable. So it very much presents an either or scenario in my view.
Okay, thank you. Mr. Heinsohn, what would you like to say on the application of, well, you may want to comment on the introductory point at E before responding to matters in relation to clause E2 in this case. So anyway, your thoughts on clause E.
Yep. So in terms of clause E, it does simply set out that project design and mitigation will demonstrate how the following impacts are addressed. It doesn't necessarily provide a test or set out particular weight that needs to be given to any particular matter in there, albeit there are some elements of guidance in relation to point E, but when you get to the end of point E, it obviously sets out that significant weight needs to be given to the contribution to renewable energy targets and greenhouse gas emissions targets as part of your consideration under point E. But again, there's no that doesn't mean that the elements, any of the other elements, can't necessarily trump those matters. It's a matter of judgment on a case-by-case basis, albeit significant weight does have to be applied. Other things can also have significant weight, which may be greater in that, depending on the case characteristics. In terms of E2 in particular, the concept of localized impacts being acceptable, that's not particularly new in terms of how decisions have been made in recent times, and perhaps not so recent times as well. But what is considered to be a localized impact is something that we don't necessarily have guidance on. Well, we don't have guidance on, and it's something that will likely be debated on every wind farm application going forward, because it's very much dependent on the scale, design and location of each individual wind farm, whether the impact could be considered localized. And then there's the and or element of it, and where they're considered localized and or there's been appropriate design mitigation, in terms of appropriate design mitigation being applied, and going through the iterative journey that is taken forward for all renewable energy projects in terms of their design iterations and the mitigation by design. It's something again that has to be considered and to be deemed acceptable. And Miss Cowling and Mr. Whelan gave evidence on that, and not going to rehearse their evidence again.
Eric, Mr. Trinick, anything you'd like to say in response to what you've heard Mr. Heinsohn say?
Not so much in response, sir, but taking on from what Mr. Heinsohn said about the word localized, that is going to give us a lot of meat for debate in future inquiries, no doubt, as to what that means. I've been quite thoughtful about what it might mean, because it's not easy to apply to particular projects. But it did occur to me that it could be applied by reference to the expectations which have evolved over a large number of years in terms of the effects that you expect to arise from a particular scale of wind farm. That, for example, and I'm not giving evidence here, it's just hypothetical, that for a wind farm of a certain scale, you might envisage that significant landscape character effects would extend out to, I don't know, 4 or 5 kilometers, and that significant visual effects might extend to 12 or 15 kilometers. I don't know. I'm just being hypothetical. So if you were looking at a wind farm of that scale in a new application, and you started to think to yourself, you know, this wind farm is going to have geographical extent of significant effects, is disproportionate in terms of my acquired expectations over the years, then I think you might start to question whether those effects are localized. But if those effects are no more than you would expect for a wind farm of that scale, then I think you might start to conclude that the effects are localized. It's only my hypothesis, and no doubt that will be tested to destruction or just ignored or whatever over the years. But in terms of trying to come to terms with the word localized, which has no dictionary definition, meaning of use, or other definition of use, that I think is not an unreasonable approach to take to the issue. The other point I just want to make is that in terms of the initial words of paragraph E, the impacts are addressed. I do not think that means satisfactorily addressed. I think it means that any applicant needs to show through the EIA process that actually he has taken proper account of and addressed the issues which are then listed in subparagraphs. In other words, not paid lip service, but properly address them as best he can. Thank you.
Ms. Finlay,
Yes.
like to come back on that?
First of all, picking up Mr. Trinick's last comment, that it doesn't require them to be satisfactorily addressed. Indeed, that's the case that Mr. Heinsohn made. This is not a policy test. It's akin, if you like, to the Electricity Act requirement that matters be addressed there. So one can't read into E a policy test, and it would be wrong for either party to do so. So to that extent, I think it's a limited extent, I agree with the words that they don't have with his submission, that there's not a requirement in E that they need to be satisfactorily addressed. The end of E goes on, as Mr. Heinsohn pointed out, that when you're considering those matters, it gives advice as to significant weight for the contribution to renewable energy. As Mr. Heinsohn pointed out, it doesn't give any advice as to what weight you give to other matters for which you must look elsewhere. And that being said, the guidance or the policy in E2 will be a matter which no doubt will be taken into account. So it doesn't contain a policy test. Indeed, I don't think NPF4 contains a policy test for this development as such. It provides guidance on it. It provides input into the balancing exercise that must be undertaken. If there is a policy test, it's perhaps in policy 4A, but that is really not saying very much at all, because there needs to be fed into the balancing decision all the various factors within NPF4 and otherwise that need to be taken into account. The second point is I resist the words "and or" on reasonably high judicial authority in Scotland, albeit somewhat dated. They're considered to be not yet part of the English language, and one is advised to avoid them in any legal document. And perhaps the discussion today exemplifies why, because although it can be obvious to some people what it means, if analysed to extreme, it can make it less than obvious. So I think they need to, this is a policy document, not a legal document. So they just need to be applied with common sense. And it may be that if impacts are localized and the design has been properly applied, they will generally be considered acceptable. It can be one, other, or both. I don't think there's any particular magic in there. And the third point, I come back to Mr. Trinick's point. Do you have a theoretical wind farm in mind? In Highland Council's view, as I understand it anyway, that would be the wrong approach, because location is particularly important. Whether your wind farm is at the top of a hill or sheltered in behind a hill, which may have some resonance to this case. The extent of impacts you might expect from it would be entirely different in both cases. And the other point to bear in mind is that in E2, it's not just the word localized that requires judgment, but the word appropriate does, as well as the word generally. That there are pointers there to with an underlying thrust that of what will be acceptable or not. But there are judgments, as there are at present, that have to be made as to whether you fit into those categories or not. So whilst it's useful policy, I think over-reliance on it should be avoided.
To come back, Mr. Trinick, or?
No, so you've got my view. I won't come back on that, and I respect Mr. Finley's view. You'll make your mind up on that. But there is one additional point which I forgot to make, and that is that here we have policy 4, which advises on the SLA, and we have policy 11E2, which advises on localized effects. In the hearing session yesterday, I made the point, and I make it again, that it's entirely possible to have significant effects. We say there aren't significant effects, adverse effects on the integrity or the special qualities of an SLA, and yet the effects may still be localized under policy 11. Those are two different things. Policy 11 deals simply with the word localized. Policy 4 deals with the SLA. I'd ask you to bear that in mind, given the facts before you on this case. And the point may be made that might be unusual, but I don't agree with that. You have to make your mind up on that point, on the facts of the case.
Add something there, Mr. Finley?
No, I'll deal with that in closing submissions. I understand the point Mr. Trinick's making. I don't know whether Mr. Heinsohn wishes to add anything. I'm not suggesting he does, but if he doesn't, no, nothing further to add at this stage.
Could I just make one final point, sir, and it's perhaps stating the obvious, but we're focusing here upon E2, which is one of 13 criteria set out in this part of policy 11. And the last point that at the last line of E2 when it talks about landscape visual effects, it says they will generally be considered to be acceptable if they are localized and or appropriate design mitigation has been applied. That doesn't mean the development will generally be considered acceptable or unacceptable. We're dealing with landscape and visual effects, so that is only one factor to consider in amongst all of this. And as Mr. Heinzen correctly pointed out earlier, once you've run through that list of criteria in Part E, you come to the final instruction on page 54, is that in considering these impacts, plural, all of them, you must give significant weight to the contribution a development makes to renewable energy targets. So it's just to reiterate the point that the landscape and visual effects are but one consideration under Part E.
Thank you. Is there anything further to say about policy 11? No.
So I was only just going to add one point, just to note that the introductory paragraph to policy 11 and its guidance for local development plans realising their area's full potential,
Yeah,
is broadly similar, not identical wording, to para 155 of current SPP. I can comment on that further in closing, but just ask you to note that.
okay, thank you. Are there any other NPF4 policies that parties wish to comment on?
From our perspective, no, sir. I do note that in the December hearing statement of Highland Council at paragraph 27, there's quite a long list of policies considered as most relevant to this proposal. I actually think that we've dealt with the policies of real relevance to this proposal in today's agenda, and that the others are maybe tangentially relevant, maybe not relevant, but not directly pertinent and influencing your recommendation.
Heinzen, would you like to comment on that?
Just briefly, it's they are relevant, but I agree that we've dealt with the most relevant policies today, and as set out in NPF4, it needs to be read as a whole. Okay.
Okay, thank you. Before we leave planning policy and turning to item 3 on the agenda, I want to consider the Highland-wide LDP policy 67 and its alignment with NPF4. We discussed the LDP at the hearing session last November, so I want to focus our discussion on how NPF4 changes the application of the policy, if at all, and explore its consistency with what will soon become formal national planning policy. I'd also like to hear the parties' views on the approach to be taken where there's found to be some tension between what's being said in the LDP and NPF4. So, Mr. Harry, if I could start with you, your thoughts on the application of policy 67 in the context of NPF4 and how we might resolve any tensions between the two.
I think it's worth bearing in mind when policy 67 was prepared, we've got the LDP, which is dated 2012. It's over 10 years old. It's actually produced in the context of SPP 2010, I think, so not even the current SPP. So the national planning and energy policy picture as we stand today is significantly different from what it was when policy 67 was drafted back in 2011-12. So that's the first point. The second point is that while it may be argued that the policy contains a list of criteria that are relevant to the consideration of a renewable energy application, and I wouldn't disagree with that, what it doesn't do is reflect the weight that decision makers must now give to issues such as climate change and the nature crisis as expressed through policies 1 and 11. For example, since this policy was prepared, we've had declaration of the climate emergency, and that's reflected in the twin pillars of NPF4 and also the nature crisis. So the emphasis in policy 67 is very different and maybe even incompatible with policy 11 and policy 1 of NPF4. It requires a consideration of the extent to which a proposal makes contribution to renewable energy targets. Now, giving consideration to that is different from giving significant weight to it, in my view, which is what we now have in national policy. So where we do have that incompatibility or that inconsistency, where you are told by the 2019 Act, I think Section 13.2, that the most recent document shall prevail, where there isn't any incompatibility. In that case, it's NPF4 being the national element of the development plan.
Okay, thank you for that. Ms. Heinsohn, what do you say?
So can I come in first, because
Yes,
when one is raising issues of incompatibility, then that is arguably in part a legal issue. First of all, Highland Council clearly accept that NPF4 moves matters on, as Mr. Heinsohn's already made clear. It expressly accepts the particular weight to be given to various factors. It also has moved matters on, as we've just been discussing, about SLAs and the like. But the question is not whether policy 67 is identical with NPF4, or indeed whether there are differences to it, but whether they are incompatible. And in our submission, in general terms, although there are a number of factors such as SLA, in which in particular issues the latter document would prevail over the former, in general terms, they are not incompatible. The emphasis, and here I do date specific attention with what Mr. Herriot said, the emphasis, albeit it's a dated document, is similar. The Highland-wide Local Development Plan Policy 67 provides a weighted balance in favour of renewable energy development, i.e. development will only be resisted if it's the contrary as to SLAs. The disbenefits have to significantly outweigh the benefits. I don't have it in front of me, but that's more or less the point. It provides a tilted balance in favour of renewable energy. Now, it doesn't do it in the same way that NPF4 does, but in our submission, they can both properly form part of the same development plan, and a decision maker can apply both of them without, in terms of the overall emphasis and thrust, without any significant difficulty. There may be some potential tension in the wording, but the underlying thrust is similar. They're both encouraging of renewable energy development. The extent to which the weight matters are, to a certain extent, matters of detail in this regard, but can they be read together? In our submission, yes. And to give an example of that, I think in the suggestion that policy 67 was significantly out of weight was dealt with in the lime kilns decision, which I think is CD 10.02. Well, I think that's 2018, albeit somewhat itself now somewhat dated. The suggestion from the reporters there was that policy 67 captured, albeit in different wording, the current policy approach and provided a useful policy framework. The the same could be said today. The one matter that is not set out in policy 67 as an impact to be addressed is tourism. Its omission was no doubt purposeful. Whether that leads to an incompatibility, if policy 67 says you should take it into account, is again open to argument. I would suggest not, but it clearly directs the decision maker what weight to be given to the issue, or provides a hint as to what weight should be given to impact on tourism. In summary, they're not incompatible. One moves matters forward in parts, but they will both form part of the same development plan. If, however, you're against me on that, Mr. Herriot is entirely right. The latter in part prevails. The latter in time prevails. And in terms of, I think Mr. Trinick's helpful acceptance that there's been a tightening of policy on SLAs, that tightening of policy SLAs must now be dealt with in accordance with NPF4 rather than pre-existing plans. So I'm not wishing to undermine what's said in the NPF4 about the weight and importance, but it's not inconsistent with the Highland Wide Local Development Plan.
Mr. Trinick, Mr. Herrick, do you want to come back on what Mr. Finley's had to say?
Happy to, sir. I thought Mr. Heinsohn might have wanted to.
Sorry, Mr. Heinsohn. Anything to add to what Mr. Finley has said?
I think Mr. Finley's covered pretty much everything that I had down in response to this question. Not giving me a chance to come in on this one. I think the only other thing that's obviously wouldn't necessarily be relevant now in relation to policy 67 is the Highland Renewable Energy Strategy, which is a document written in 2005. But as Mr. Finley set out, there was the Limekiln decision, which considered Limekiln Inquiry Report, which considered that this policy was consistent with SPP. I would suggest that policy 67, while it was written against the provisions of SPP 2010, it was quite a forward-looking policy and reflects the Highland Council's overall support for the delivery of renewable energy developments in Highland, a position that they've had for a number of years, subject to the appropriate considerations.
Mr. Trinick.
Thanks, sir. Yes. Policy 67, when it's a very positive policy in terms of its times. It was a leader policy for Scotland. I think it was good. And to some extent, whether you find any incompatibility is a matter for you. And if you find incompatibility, you will apply NPF4 rather than the LDP. And I don't want to go into the detail, but I'm left with a slight unease. And the unease, I think, is best reflected by saying that this policy, indeed the LDP, we mustn't forget that it was drafted and brought forward in the context of its time. It was brought forward against, as it says there, the Renewable Energy Strategy of 2006 and the Renewable Energy Planning Guidelines of the same date, or roughly the same date. Its whole context has changed. So to quote Jonathan Easton, or rather Morecambe and Wise via Jonathan Easton, has got all the right notes, but not necessarily in the right order. I think that's the best way to look at it, that you have to be cautious in applying a 12 or 13-year-old policy and saying, well, it's got most of the right bits. It may have, but I'd ask you to be very cautious about its what it says in terms of its context and its date. Thank you.
I think I would just, if I could, sir, just make one final point in relation to the Limekiln decision, which is referenced there in CD 10.2. I think the point was made that the reporter there said that policy 67, was consistent with SPP, which is absolutely fine, but that's not the exam question we're now sitting with. The exam question is policy 67 consistent with NPF4? And as I said, the list of criteria that one might apply to assess renewable energy application are broadly similar, but it's the weight you apply to certain matters that has changed in NPF4 between SPP, as we can see at the end of policy 11E. And I think that's the key takeaway point here.
Anything further you'd like to add, Mr. Finlay, Ms. Heinsohn, on our discussions of the Highland-wide local plan?
No, but safe to say that I think perhaps we've over-egged the amount of time we've spent on this point, because I don't, if whoever's submissions are right, it's not going to make a significant difference to the outcome, I don't think.
Okay, thank you. Right, moving on to item 4, this is where I'd like to discuss the onshore wind policy statement and its ambition to deliver a minimum installed capacity of 20 gigawatt of energy by 2030, and the implications of this target on the assessment of development applications. Ms. Herriott, if I could hear from you first on these matters before I bring in Mr. Heinsohn to comment.
Yes, thanks, sir. So the key point upon the additional generation, with their minimum levels to be achieved, and I think there's no disagreement between ourselves and the council on that. I think they acknowledge in their recent hearing statement that these are not caps. There's obviously developments in the system, whether with consent or awaiting consent or revising the consents, that can make a contribution to the 2030 targets. But some will not come forward for whatever reason. So some of the pipeline sites will definitely fall away. There's a need for more. And we've got the 3 categories here. They're not built, the end planning, and not consenting. An element of double counting there in the onshore wind policy statement as to what's in the system. I think what's important in looking at the 2030 targets is also the key question of grid. You can have a planning consent, but if you don't have a grid connection date, contribution that you make to 2030 is, well, you can't make a contribution. We've got a grid connection date of 2027. There's Appendix 2 of my January hearing statement, I think it is, sets that out.
Yes, I was going to ask you about that earlier on, but yes, you can clarify that for me now. So
yes, it's just to illustrate that if this project were to get permission, there is an accompanying confirmed grid offer there of pre-2030, and it's dated the 30th of June 2027. So there's no question about getting a planning consent and then having to worry about grid. Grid is secured. So this is a project that could come forward, could connect into the grid, and could make contributions to 2030 targets. The other thing I would say is just as a general observation, the 2030 targets, I think, have been previously described by the Committee on Climate Change in its 6th Carbon Budget Report as extremely challenging to meet. And what we're looking at, I think there's 8.7 gigawatts currently operational, which is referred to in the onshore wind policy statement, with the need for an extra 11 and a bit to make up the 20 gigawatt target. And that's about 125, 130% growth of operational schemes in the next 7 years. So it is a big challenge.
I know she said she'd put her like.
Sorry, just remind me, where did you say the challenge is set out? You said the target is challenging to make.
Yes, that's referred to. Apologies, I'll just find the core document reference for you. It's the Committee on Climate Change 6th Carbon Budget Report.
The transcript stuff that we were initially looking at.
And they describe the 2030 targets as extremely challenging to meet, even allowing for stretching tailwind.
Yeah, it's like there's just too many copies of it. That's fine, I'll just ignore them.
Thank you.
Yeah, no, that's fine. Yeah.
It's always a delight when I get an email from John Campbell.
Is there anything you'd like to add there, Mr. Herriot, or have you come to the end of your response?
In terms of the first part about 2030 specifically, that's all, yes.
Okay, thank you. Mr. Heinze, your thoughts?
Yes, so in terms of the ambition and aspiration, the target is there, and as set out in the hearing statement, and also the statement of agreed matters, albeit that predates the publication of this document. Highland Council don't view targets as caps at all. I think in terms of timescales and grid, in particular, it is agreed that there is double counting in the current appraisal of the level of development that may come forward. But also there are a number of other projects that are likely to come forward. From my understanding of talking with, given my role, discussing matters with industry, discussing matters with the Energy Consents Unit, there's well over 20 projects coming forward just in Highland within the next 2 years as applications, which could be brought forward in the area, and on very recent discussions we've had with a scheme that's not coming into planning until either later this year or beginning of next year, that actually has a grid connection date of 2028. Therefore, those ones still could potentially make contribution to the targets, even the ones that aren't in the system as yet. And as I understand it, there's the average timescales for moving from application being submitted all the way through to determination. The average timescales across the last 6 years, it was a blog post that was recently done by Brodie's. I'm happy to share that if that would be useful to do so. In terms of the timescales of Section 36 applications and town and country planning applications going through the system, the average timescales for determination is roughly three years across the last 6-year period. So there is opportunity for those that aren't yet in the system to still make a meaningful contribution to the 2030 targets. Fully acknowledge what Mr. Herriot has said in relation to the findings of the Sixth Carbon Budget report, update report, and it sets out that 2030 is challenging, but it says that while 2030 is challenging, things may have resolved, and in fact the targets may be well exceeded when it comes to 2040, but appreciating that the time between now and 2030 is a critical time.
Do you want to come back? And I think, I don't know if you're familiar with the Brodie's assessment that Mr. Heinz has referred to.
I'll come back and say I'm not immediately familiar with it. I don't object to its production because actually we don't really agree with that assessment of timescales. 20 projects next 2 years, I don't doubt it. I'm surprised there are only 20, frankly. But some will be refused. Some will go to inquiry and maybe later permitted or maybe later refused. The history tells us even when you get consent, there can be a need for tip height increases, which means a further application and further time spent. Goodness knows about grid connection dates for all of those projects. I don't know. Unless I know, I'm not going to concede anything. But in terms of timescales to decisions, and I'll deal with some closing submissions, but that our understanding is that actually from getting into a public inquiry until a decision, that period may well be 3 years on its own. Never mind the period which is taken up to that point in getting to an application and through all the surveys, through the EIA work, and then getting from submission to a point of view from a local authority. So I'm afraid we probably don't agree on timescales. And I'd say that frankly, those projects coming in the next 2 years are unlikely to make a contribution to 2030. Those projects which are in the system now, notably for today's purposes, Kintradwell, which has a connection date of 2027, are in a premium position. They have premium value in NPF4 terms. They are the ones that will enable Scotland to get 20 gigawatts by 2030. Thank you.
Thank you. Mr. Finlay, did you want to respond, or Mr. Heinsohn?
Yes, could I respond briefly? Firstly, there's clearly a disagreement between the parties, and you've heard the evidence of Mr. Heinsohn and the submission of Mr. Trinick, and the evidence of Mr. Herriot. And I use the words evidence and submission for good reason. But I do ask two things. First of all, that you accept Mr. Heinsohn's offer of the Brodie's summary, and that becomes a core document. As I understood, I may have misunderstood, Mr. Trinick didn't object to that. But secondly, Mr. Trinick indicated that he would be making further submissions on this in his closing submissions. I don't wish to add further complication, but I don't want to read something in Mr. Trinick's closing submissions for the first time that hasn't been said otherwise. I'm very happy if Mr. Trinick wishes to have the opportunity over the next few days to put some further material into which we could potentially respond, but I certainly don't want to read it for the first time in Mr. Trinick's closing submissions. So I have those 2 points. It may be Mr. Trinick doesn't wish to put further evidence as such in, but you have what you've heard already, and whichever I'm fairly relaxed about the second point, but provided that I can comment on evidence in our closing submissions whenever they become due.
Okay. I think I'd be interested to see the Brodie's summary. So if that could be lodged, I'm happy to accept that. On the second point, Mr. Trinick, I think that you were suggesting you'd be lodging new evidence, but perhaps you'd like to respond to Mr. Finlay's comment.
I wasn't intending to, sir, but now Mr. Finlay's mentioned the point. When the Brodie submissions come in, we would like the opportunity to have a mini exchange of representations on those timescales, and those will inform the closing submissions.
Is that satisfactory, with you, Mr. Finlay?
Yes, absolutely. I'm presuming Mr. Heinsohn can provide the Brodie's document today or tomorrow, and well, today being it Friday, tomorrow being Saturday, and any short submissions on it, and both parties are no doubt going to act reasonably on this, can be concluded by the end of next week, I'm sure.
Okay, thank you.
So if I could just come in to apologise for not raising that but before today with parties. The blog was literally just posted yesterday and came to my attention first thing this morning. So.
Okay, that's fine. Thank you. The next point I wish to discuss, the onshore wind policy statement to paragraph 3.6.1 states that meeting the ambition of 20 gigawatts of onshore wind in Scotland by 2030 will require taller and more efficient turbines, and that, with emphasis in the document, this will change the landscape. Mr. Herriot, what does such a statement imply for the consideration of development proposals and their effects on the landscape?
Seem an obvious statement to make, that landscape change will come about, but I think the fact that it has added emphasis in the document is significant, particularly when we take this back and looked at in the context of policies 4 and policies 11, for example. So depending on what conclusions you arrive at on the landscape elements of those policies, there's an inbuilt recognition now in the onshore wind policy statement that we cannot deliver 2030 and post 2030 targets without some degree of landscape change. We've got to also bear in mind that the onshore wind policy statement describes onshore wind as mission critical to meeting the targets. It's clearly the technology that's the forerunner, at least for the next decade, to help move matters along. And that's a theme that comes through also in the energy strategy. So it's a consistent theme, perhaps a statement of the obvious, but with its added emphasis, I think, needs to be recognised in planning balance, as you will need to do in relation to NPF4 in particular.
Okay, thank you. Mr. Heinsohn, same question to you.
I would say that it's accepted that to reach the 2030 targets, the landscape will change as a result of that. But it's the onshore wind energy policy statement is clear that the balance still needs to be struck between those landscape impacts and reaching the targets. It's not development at any cost, effectively. And it sets out that it's important to safeguard the natural environment of Scotland as one of its key assets. In relation to sorry, just lost my train of thought there briefly. Yeah, sorry. In relation to that landscape change, there has been a shift in recent times, in any case, as to the scale of wind energy development that would be accepted in particular sites, particular locations. And indeed, there's been some sites where Highland Council have accepted much larger turbines than they had previously accepted on the basis of the route to net zero, the Strathy South variation, being one of them. Indeed, there's been others as well, where effective repowering type schemes or theoretical repowering schemes where a site had got consent with one scale of turbine, either through Highland Council or through ministers, and sometimes the initial decision was either against officer or council objections, and then the Highland Council's taken an approach that it would be acceptable to have those larger turbines in light of the climate emergency. So just to highlight those matters.
Okay, thank you. Anything further to add, Mr. Herod?
Perhaps I can add just something on that.
Yes, beg your pardon, sorry.
It's expressed more starkly, but it's a message that is consistent with previous guidance. And I'm just looking at the previous onshore wind policy statement, which is CD 81, I think, which said on page 7, para 4, that there will be more development across Scotland's landscapes where it can be accommodated. That's not saying precisely the same thing, but the same sentiment that renewable energy development to the scale envisaged either previously or now will change the landscape is as Mr. Herriot said, a statement in part of the obvious. The fact that it's emphasised, I think, reinforces and perhaps picks up on the point that we were discussing in Policy 11, that localised impacts on the landscape will generally not considered to be unacceptable. But it doesn't. I don't think it. Well, certainly Highland Council have never advanced a case that just simply because of landscape change that makes it unacceptable. It's the extent and the impact of landscape change or visual impact which is what is important.
Is there anything you'd like to come back on there, Mr. Trinick or Mr. Heinsohn? Sorry, Mr. Herriot.
Change my name at the end of today.
I know, I beg your pardon.
Apologies, Simon. Thanks. No, and I take the point that Mr. Heinsohn makes that Highland Council has accommodated taller turbines, whether that be through applications that originally proposed taller turbines or reworking schemes, what have you. The OWPS is a national document, and that applies to planning authorities right across Scotland. I just think that the added emphasis in there is important, and I think possibly also when it comes to, for example, repowering or replanting schemes, where you're substituting maybe sub 100 meter tips with something that might even be double that. I think this is where this can come into play as well. But it's equally relevant to virgin applications, shall we call them, as we've got here.
Before we leave the OWPS, I want to seek the parties' views on the relationship of the policy statements with NPF4 and establish whether there are any implications for the application of policy. So, Mr. Herrick, your thoughts on that particular matter?
It's really complementary to NPF4. NPF4 is the policy tool to deliver the 6 outcomes, including delivery of net zero and contributions to 2030. I think what the onshore wind policy statement does is it helpfully puts into context some of the comments we've made about the extent to which NPF4 marks a turning point, the extent to which stronger weight should be given to climate change and the nature crisis in the planning balance, and it uses that particular phrase in paragraph 3.6.2. And to use Mr. Trinick's word, I think it's a bit more oomph. It certainly refers to the onshore wind industry as being mission critical in the conclusions. So as an industry as a whole, moving towards 2030 and 2045, this technology is definitely seen as mission critical to help meet the targets. There's no ambiguity there. And I think it does reinforce the points that we have made about the extent to which new national policy is a turning point, and that in the balance, the scales are tipping in further giving more weight to these 2 important pillars of the nature crisis and the climate emergency.
Mr. Heinsohn, your thoughts?
In relation to the onshore wind energy policy statement, it largely reflects the contents of NPF4. As you would expect, the documents were published round about the same time. What I would say, though, is with the onshore wind energy policy statement, it perhaps refers to the balance more, and the balance that's required between delivery of the targets and impact on the natural environment. And other factors, there is more discussion and more emphasis on that in the policy statement as there is in NPF4, and in doing so, it also links to Scotland's 3rd land use strategy as well, which also calls for balance going forward in reaching decisions. Yep, I agree with Mr. Herriot that it sets out that onshore wind is mission critical, but previous iterations of the document set out it would be vital. Onshore wind would be vital moving forward, and so I think it's semantics between what is vital and what is mission critical. While things have moved on, absolutely, I think there is absolutely a need for onshore wind energy coming further onshore wind energy coming forward. But it's you've got to consider that the disbenefits as well as the benefits going forward, and I think that message comes through clearly in the onshore wind energy policy statement.
Okay, thank you. Is there anything that you'd like to add, Mr. Finlay or Mr. Trinick on that? Okay. I think we're making good progress, and it might be that we can get through the rest of the agenda before what I thought might be a lunch break. Are people happy to carry on? Yes. However, I would appreciate just a 5-minute break if that's okay. Just a short break. Thank you.
bizarre. It's yeah. It's getting to the stage where it's just we'll just play this youth team that are like in the Champions League. Yeah. There's that nine? There'll be 9 players gone. So that's 11. And signed Jago, and that's it. Oh, there's rumours of Arfield on loan with the option to sign him. Yeah. The Falkirk Canadian. And he didn't make a change to what, 70 minutes? Yeah. El Saki won the weekend. I can't. Hibs have been quiet on it, whereas Aberdeen have proactively released this statement of support, which means he's going. Yeah. So yeah, 10. So you usually have.
Okay, thank you for that. Are we all ready to resume?
I've got a few days, so.
Thank you. Okay, there's just a few items left I'd like to discuss, and I think we can get through this in fairly short order. Item 5 on the agenda is the Draft Energy and Just Transition Plan 2023. While the document's been published in draft form, I would nonetheless like to hear the parties from the parties on what they consider to be the key message from the plan relevant to the consideration of the application. And I'd also appreciate your thoughts on the weight to be afforded to the plan in the assessment of the application. If I have to start with you first, Mr. Herriot.
But you can run a report that shows you.
Yes, sure. Well, as we set out in the most recent hearing statement from January, we realise this is a draft document. It may be subject to change, and we don't seek to draw any great weight from it. The commentary that we did set out in section 4 of the hearing statement was just highlighting those areas where we thought there was relevance to proposed development, and particularly also parallels with the onshore wind policy statement, for example, and an NPF4. And all I would just really say in this matter is that there are a number of points and matters over which there is commonality regarding the need for significant upscaling in renewable energy production, and that's set out on page 24 of the strategy. Explain how the vision will be developed. There's recognition of the need to increase the total level of renewables, and that's across all technologies by a further 20 gigawatts by 2030. And while the document might well change between its current format and final format, I don't think we're going to see any significant dilution or step change in those key headline matters, given that they do feature in other documents which have been recently published, for example, the onshore wind policy statement. There are links in there with how renewable energy and habitat enhancement, for example, can go hand in hand. And again, that's a relevant point that's also made in the onshore wind policy statement. And I refer to that in paragraph 4.5 of my January hearing statement. And I suppose it's a document that's, by its nature, it's a national level strategy. So its application to an individual project might be difficult. And what I would say is when considering this proposal is how does it fit with the wider aims and aspirations? It doesn't set policy tests, for example. It just reiterates this strategy. It applies to all technologies, not just onshore wind. But as I said at the outset, we don't seek to draw any great weight from it at this stage.
Okay, thank you. Mr. Heinson, your thoughts?
Yes, I consider not dissimilar from Mr. Herriot. I consider that it largely reflects the contents of the onshore wind policy statement and national plan framework for, again, unsurprisingly, given the timescale in which it's been published. And at this point, we would consider it holds limited weight, given it is a draft document.
Thank you. Anything you'd like to add, Mr. Trinick or Mr. Finlay?
I don't think so.
Okay. Okay, well, thank you for that. Item 6 is the hydrogen action plan. And again, probably several answers here, but to what extent do the parties consider the action plan relevant to the consideration of the application? Mr. Herriot.
Perhaps so you might ask Mr. Heinson to go first on this, as I think the issue arose through something in their statement.
Okay, so Mr. Heinson, would you like to go first, please? Is there relevance of the action plan to the consideration of this application?
The hydrogen action plan sets out that onshore wind is important to the delivery of hydrogen and hydrogen, or an increase in hydrogen production across to the across Scotland. So on the importance of onshore wind to that. But I'm not clear whether the applicant is looking to produce hydrogen as a result of this scheme. I don't believe there's no hydrogen production facility as part of the application. But whether there's any linkage in with any other hydrogen production facility that is to be brought forward in the future is something we'd need to hear from the applicant on.
Okay. I see there's a demonstration project at Gordonbush, isn't there?
There is that. There's a hazardous substance consent application in for that, but the planning application is not yet submitted. That's going to be submitted in the springtime this year, I understand.
Okay. I think, as you say, I mean, there's no such proposal within this application at all. So perhaps just
correct.
Yeah, that's correct. Yeah.
Okay. Is there anything you'd like to say, Mr. Herriott, on the hydrogen action plan?
Not much. Just really to reiterate with what Mr. Heinsohn has said about the future role of onshore wind and the positive contribution it can make to the generation of other less advanced fuels, shall we say. So this is not just about getting electricity onto the grid. It can help with other technologies, and it's really all I would say. Just to.
Okay, thank you. Okay, thank you. Item 7, the draft Scottish Biodiversity Strategy to 2045. So I'd like to conclude our session with a brief discussion on the draft Scottish Biodiversity Strategy and the contribution that the application proposals could make to tackling the nature emergency. Ms. Herriott, you deal with this matter in your January statement and accompanying appendix. Can I ask whether the proposals of the outline habitat management plan are broadly consistent with the strategy, and if not, how any consistency could be resolved?
Yes, I think that was the main purpose for the production of Appendix 1 in the hearing statement from January, was to really set the applicant's various habitat management proposals within the context of NPF4, the onshore wind statement, and the biodiversity strategy. And while those documents were produced before the draft strategy was published, there's certain areas of commonality there regarding the significant peatland restoration, changes to the land management practices and grazing. So I think that the submission Appendix 1 shows how the documents align. As we mentioned earlier, what we have got at the moment is an outline, habitat management plan, and draft documents, which would be subject to further approval in consultation with Highland Council, Nature Scot, and others. So they'd be live documents that would no doubt be subject to further refinement to make sure the objectives are fulfilled, and that could take account of, for example, changes to the biodiversity strategy that might come forward. What I would say is, and that's just in general how the two sit together, the biodiversity strategy clearly does see onshore wind energy generation and biodiversity enhancement going hand in hand, and that's very much linking in with the twin pillars of NPF4 and also the onshore wind policy statement. And I refer to some sections of the strategy in my hearing statement where this is mentioned, accompanied by graphics and visuals and things like that, and that's particularly in paragraphs 5.5 and 5.6 of my updated hearing statement. So I think they're, as far as it can be at this stage, I think the habitat management objectives are well aligned with the biodiversity strategy.
Mr. Heinsohn, do you have any observations on this particular point?
Nothing of real significance. Yes, the applicant is bringing forward the enhancements as set, which have been usefully pulled together in Mr. Herriot's statement. It does appear that they would align with the provisions of the draft strategy. As I mentioned earlier, such things have been relatively commonplace and good practice across other wind energy developments in Highland, and probably dating back to 2010 with the Dunmaglass wind farm, where a regional golden eagle conservation management plan was brought forward as part of a habitat management plan as part of that, and that's been extremely successful and had spin-off benefits to the south of Scotland, for example, and the golden eagle population there. So there's benefits set out in the proposal here, which would be of benefit and have wider benefits than just to the site itself. It would make a contribution.
Yeah, Mr. Trenick, Mr. Finlay, anything you'd like to add on that particular matter? Okay. Thank you for that. Item 8. I just wanted to confirm arrangements for closing submissions. I noticed that we've yet to agree dates for the lodging of closing submissions. I'm aware that Mr. Trenick, Mr. Finlay, you have commitments regarding the Cairn Dewey wind farm and upcoming dates in February. So I don't want to cause you any unnecessary pressure on your time, but and I appreciate in this case, Mr. Finlay, you're acting for two parties, and I just wonder what you might suggest would be a reasonable timescale to lodge submissions. So perhaps Mr. Finlay, if I could start with you.
Yeah, let me just bring up my diary. That's very helpful. I would hope to do them within 2 weeks, but it just because we also have Kirkham Wind Farm where we have a hearing.
All right, so that's next week.
Is it?
Okay.
So, but if you allowed us three weeks,
Yeah. Okay.
then I understand. I don't know how that will fit into Mr. Trenick's timetable. I know that he's got a busy timetable too, so I'm more than happy to bring that slightly forward if that would assist him. But 3 weeks from today would.
And tell me, would you envisage submitting on behalf of Loth residents first and then the council, or would you submit?
I think I'll do them all at the same time. But I mean, usually it would be residents first, council second. But because they're quite well joined, it will be both at the same time. And indeed, in the landscape and visual matters, there's a significant overlap between the two.
Mr. Trenick.
Thank you. That fits in fairly well. I would offer the 27th of February for my closing submissions. And obviously Mr. Easton and I will be working on them together. But 27th of February. I go on holiday on the 1st of March, so.
Okay, so what does that mean for you, Mr. Finlay, then, if we give Mr. Trenick a reasonable amount of time to work his way through your submission?
So he said the 27th.
Yeah.
Which is a Monday. So he said by the 16th of February.
Is that okay, Mr. Trenick?
Ideal. That sounds very good.
So 16th of February for Loth residents and council. Okay, thank you. Now, are there any other matters that parties wish to raise before close the session?
Yes, thank you, sir.
Okay, Mr. Finlay?
No, thank you, sir.
Okay. Well, you've both referred to other cases, some earlier in this week and some next week. So it's been a busy time for you both, and also for the Highland Councils. Obviously, have to respond to all these applications. So thank you very much for, as I said earlier on, for submitting your statements timorously and for taking part in today's session. So thank you very much. Okay, and I'll close the session here. Thank you.
Thank you very much, sir. Thank you.